Well, good afternoon, everyone. Welcome to our third meeting of the Criminal Records Review Committee. My name is Rachel Talbot Ross. I serve in the Maine House of Representatives, representing House District 40, which is part of Portland. And I also serve as the co-chair for this committee, offering a real strong welcome, and I hope everyone is doing well. We are being recorded, and as you know by now, it's also streaming. So I want to make sure that we welcome the public. In honor of the time that we have together this afternoon and the full agenda that we have, we will forego individual introductions. I will ask, though, because the public is watching or listening, that before you speak, you do introduce yourself. I will ask for the staff to introduce themselves, and then we'll check in with the agenda. So I'll start with Jane and then go to Peggy, and then we'll move on.
Hi, Jane Overton, legislative staff. Thank you.
Hi, Peggy Reinsch, legislative staff. We're both in the Office of Policy and Legal Analysis.
And we couldn't be here without either one of them. So we want to just honor and thank you for all the work that you've done for this committee. I want to check in with committee members to make sure that they have the agenda in front of them and you have all of your meeting materials. If you do not, you can indicate by raising your electronic hand or your hand. You can also put the materials in the chat. I am not seeing anyone. So in the true style of this committee, there's so much information that we have to have, so much to be indoctrinated that most of our meetings have been full of presentations. Today is not going to be any different. We will get to a place where we can discuss all of this and make some suggestions and recommendations. But today we're going to start out with a presentation from the Media Law Resource Center with George Freeman. And I'll ask Mr. Freeman if he'll give a brief introduction, and then we'll go right into the presentation. Is everyone okay? Great. Mr. Freeman, the floor is yours.
Okay, thank you, Representative Ross. I really appreciate the opportunity of speaking to you all today. I'm going to make a brief statement, but do you want me to wait a while for other people to introduce themselves? I'm the executive director of the Media Law Resource Center, which is a nonprofit organization supporting the media around the country, digital, print, broadcast, etc. And before that, I was the in-house attorney for the New York Times, dealing with the newsroom and First Amendment issues for some 30 years. Do you want me to make my statement now, Ms. Ross?
Absolutely. Go ahead, Mr. Freeman, with your presentation. Thank you.
Thank you. So we have a number of problems with the proposed bill. I mean, I think it has good intents, but I think it really contradicts standing United States Supreme Court law, and so it's very problematic. I want to really highlight two issues. And the first really is the most serious, which is located at the end of the bill, the last section, section 2, paragraph entitled offense. And that paragraph seems to say, if I read it correctly, that really if a criminal conviction of the sort under the bill is expunged, then anyone who disseminates information about it thereafter is subject to a criminal offense. And that is plainly unconstitutional under about 5 leading Supreme Court cases that they decided in the 70s, 80s, and going up to 2000. A case called Florida Star v. BJF, which was dealing with the release of a rape victim's name and situation. And then a case called Bartnicki, which was a wiretap. Dissemination of a wiretap. And in both those and 3 other cases, the Supreme Court said that you could not punish anyone for publishing truthful, newsworthy information that was not illegally obtained. So basically, because of the high value we place on information and dissemination of information to the public in this country, they really said that you couldn't punish for the dissemination if that information was truthful, which certainly a criminal conviction was, if it's newsworthy, which certainly a criminal conviction is, not only in terms of itself and the criminal involved, but it certainly is newsworthy in terms of how the state deals with its criminal process and procedures. And finally, that it wasn't illegally obtained. And since it was obtained back in the period when it would have been perfectly legal, the time of the conviction, that's the way normally this information would have been obtained. To disseminate it later on after it had been expunged would not meet the statute, the Supreme Court's holding either. So it really would fall short on all three of the prongs that would be required. And I don't see any question about that. In fact, situations where information was far more sensitive, the naming of rape victims, the naming of juvenile delinquents, et cetera, those were the cases, those were the situations that arose in the cases in which the Supreme Court said you could not punish for the publication of that information. So I think it's clear that the offense section would be held unconstitutional by any court following the Supreme Court decisions. Going to the main prong, though, or the main import of the proposed bill, I guess, is not so much punishing, let's say, Google or the Maine Monitor or a website that publishes this information after the fact, but rather the bill strives to work within the criminal justice system to not allow government employees, to not allow a state agency to give that information out after the 4 years. And my problem there is twofold. One is that it seems to be really, as a practical matter, totally insufficient. It doesn't really accomplish much because after a conviction, 5 years after a conviction, if it becomes newsworthy, whether it's the New York Times or the Maine Monitor, or indeed whether it remains on the Google archive, it's going to be there. And they won't have to go, those media entities won't have to go to the criminal justice system in Maine to get the information. It already will be in their archives from the time when the criminal conviction was entered. So it really seems to be without much effect to have a bill like this, because it's not going to accomplish the perceived harm that you're trying to prevent. And indeed, I go back then again, and excuse me from kind of being a lawyer, but that's who I am. I go back then to the Supreme Court's, again, 3, 4, 5 cases starting in 1980, where they said that the records in the criminal system are presumptively open, that closure, sealing, can only be accomplished if it's essential. And they defined essential as looking at 3 factors. One is if there's a substantial probability, which is a pretty high standard, that it would prejudice a defendant's fair trial right. Now, obviously here the trial has already occurred, so it can't possibly affect the fair trial right at all. Secondly, that it has to be effective in preventing the perceived harm. And as I just said, as a practical matter, that's not going to be the case, because anyone who wants to publish it 4 or 5 years later is not going to go back to the court or to the justice system. They're already going to have it in public archives, and it'll be on Google. So it's easy enough to get. And thirdly, there's a factor, I guess, that deals with the public interest. And here I think there's a severe question of whether this is in the public interest. It's certainly in the individual's interest, I get that. But there's a lot of public interest in terms of the workings of the criminal justice system. Let's say there should be research on whether there's discrimination because of race, whether certain people are getting treated better by the justice system than others, then that research wouldn't be able to take place because you couldn't find that information about these convictions. It seems to me that all of the prongs of that different test also to overcome the presumption of open records, and that presumption is a continuing presumption. There's nothing that says that it ends after 4 years. It seems to me that would be any sort of bill like this would be undercut and probably declared unconstitutional as well for violating the main cases, Richmond newspapers, which was decided by Chief Justice Berger in a unanimous court in 1980. And following up on that, a later case called Press Enterprise that made it clear that the same standards applied to documents, not only the actual trial, but to the documents filed in connection with the case. Finally, I would just add that I think there are a lot of harms here that the bill doesn't really come to grips with. I mean, let's say that someone's running from Maine is running for president of the United States who had convicted a crime. It can't be the case that the public shouldn't know, and that people, including the media, but people in general, shouldn't have the freedom in our system to talk about a 4-year-old crime committed by someone who's trying to become a senator, a governor, a representative, state legislator, or the president of the United States. If people are voting about this person, that would seem to be of utmost importance and shouldn't be expunged. But of course, at the time, we might not know that this person who's applying to get the records expunged 5 years hence will be running for public office. And likewise, on a more personal note, you'd think that some individual citizens would want this information about people working in their home, be it a painter or a babysitter or whatnot. I just don't see how those folks don't have the right to find out information like this about people working in their home. This is a very, very difficult standard, it would seem to me, given that you're talking here about criminal convictions. There are many states, whether rightly or wrongly under the Constitution, that have expungement statutes if guilt isn't found. And that's far easier to understand. But it seems to me in situations like this, where you're talking about a criminal conviction, it just can't possibly meet the standards of either of those Supreme Court tests and Supreme Court areas that access to the judicial process is presumptively open, and that you can't be punished for disseminating newsworthy, truthful, and information that wasn't illegally obtained. I just don't see how that can be accomplished in the manner that this bill tries to do it. Thank you.
So thank you, Mr. Freeman. I know that folks may have some questions for you, and I apologize. It looks like you were presenting information on a proposed bill, LD 1459. And we do not have that bill language in front of us, many of us. So I just want to apologize to our committee members for not putting that in some of the materials that you have access to. And I want to thank you for that presentation. I'll open it up for comments and questions. I guess since we did look at 1459, I'll just ask the first question or make a comment, and that is, Mr. Freeman, that bill is a proposed bill based on Maine law that had already sunset, and it was never challenged constitutionally. So we're looking at a bill that extends in many ways already precedent in Maine law. So that's one comment. But my question to you is just around whether or not your organization has sued other municipalities and states who have adopted clean slate legislation already. I mean, Philadelphia already has a form of clean slate in it. And so, and there are many other entities that are looking at it or have adopted it. And as this committee knows, clean slate legislation is an automatic sealing. It's not even a petitioned process. So I'm just wondering if you could comment about what involvement you may have in the other governmental entities that they've already adopted this type of law.
Sure. Well, the answer is easy. My organization really is a organization that supports the media, but we don't really institute lawsuits ourselves. So we will not be doing that, but we might be advising media companies who are interested, whether it be in Maine or in Pennsylvania or anywhere else, that in our view, many of these such legislation would be unconstitutional, and an attack on it would probably be a winning one. And then we would probably get involved to the extent of doing an amicus brief or something like that, setting forth the other media's views than the party who's suing. In terms of the fact that there's similar legislation that does exist, all I would say is that obviously the United States Supreme Court views on constitutionality override and are superior to what the Maine laws, Maine statutes. And if a court, a federal court could find them to be unconstitutional, despite the fact that Maine allows it or has allowed it so far. And the fact that it hasn't been challenged is, I can't speak to that, but if it were challenged, I'm just saying that I think the bill would be in severe trouble. The fact that it hasn't been so far, I just can't speak to that as to why that might be. When I was at the New York Times, at one point, a bill like this, a law like this was, I think, non-existent. And we made, and this goes back probably 30 years at least, we started a case which really questioned the fact of expungement, not of criminal convictions, but of anything in the criminal procedure area, even if it led to an innocent finding or a dropping of the charges. And somehow that case got waylaid for procedural reasons, and we never got a substantive result, and it never really got brought up again. But in the case of a criminal conviction, I frankly think that the media would be much more sensitive and much more upset about a law like that than a law that expunges non-guilty verdicts and findings. And so there'd be a much higher likelihood that some sort of legal action might be taken.
Thank you. I want to open it up for committee members to comment or ask Mr. Freeman a question. That's a pretty, that's a very dramatic, if I dare say, testimony or presentation, as it has not been raised quite in that same tone before.
Well, I don't know. Thank you, Representative, I hope.
So comments from other folks, any reactions? No one is as surprised as I am to hear this information.
I have a comment if I can.
Thank you. Yes, Mr. Cabete.
Okay, Mr. Freeman, thank you for your presentation. I am policy counsel for the Maine ACLU, and as you know, the First Amendment is very much our bread and butter, and that includes freedom of the press. What I found interesting in your presentation is the contradiction between the very draconian case law that you described and the fact that all but 5 states have some form of criminal record sealing and expungement. So how could that be? How could it be that the Supreme Court is so restrictive around what may be sealed, and almost every state has some form of criminal record expungement or sealing regime? And what we're doing here is looking to expand that regime. I'm curious what your reflections are about that.
Yeah, no, that's a very good question. And I was similarly stunned when I brought this case 30 years ago, that I helped bring this case 30 years ago, that there wasn't more law on it, because it seems that it really does go against the Supreme Court holdings. I can't really give you a good answer other than, obviously, before bringing cases, a lot of factors go into that, not only whether one would win, but whether, the factors of cost, factors of how it would play in the public community. And evidently, those factors have mitigated towards not suing. And obviously, quite frankly, I appreciate your listening to me, but I am in New York. I couldn't really speak to the situation in Maine, but all I'm saying is that these are pretty severe legal concerns. I don't think many lawyers would really disagree with, my pretty objective statement of what the law is. Whether or not people bring actions, that's really beyond my ability to guess or to even explain.
Okay, I appreciate that answer. Thank you. I see DA Sarbek has his hand up. I do have a follow-up, but if you want to ask another question, I can just come back.
No, go for your follow-up, Michael.
Okay, great. It's on an unrelated issue, if you have more to say about this, Jonathan. Okay. My second question to you, Mr. Freeman, is about your various examples. So you had 3 examples. One is the presidential candidate, another is the painter, another is the babysitter. And your argument was, we deserve to know about these people's pasts. My question to you is, what if the legislature specifically does not want people's knowledge of someone's criminal conviction to be part of the punishment for that crime? In other words, what if the legislature wants punishment for that crime to only be incarceration, or to only be community service, or to only be whatever the legislature prescribes, rather than these collateral consequences? That's the term that we use, right, in the law to refer to the mess that this group is trying to clean up, the collateral consequences of criminal records. And so what's your thinking around that? The legislature did not intend for reputational harm that follows you around for the rest of your life to be part of the punishment. And yet you feel attached to the continuation of that kind of reputational harm. And I'm curious why, and I'm curious what you would tell legislators who don't want that to be part of the consequence of a crime, unless it's specified as a consequence of the crime.
I think that these laws and bills exist, and their initiative was to help private citizens in terms of getting jobs and getting housing, who perhaps unfairly were being hindered because of these past incidents. But you and I can speculate, and we probably shouldn't, but I can't imagine really that the legislature either thought about it or that its goal was to not allow the public know about the criminal convictions of someone running to be president of the United States. It's just hard to believe that anyone among us would think that is irrelevant, or that is so damning that reputational harm to a potential candidate for public office like that, ought to not be known when you're in the ballot box, the booth. I guess that's my answer. I would be stunned if people really thought that expungement went so far as to preclude us from knowing that the person I was about to vote for had been convicted by a jury of a serious crime.
This is the last thing I'll say in this presentation. I appreciate your response, Mr. Freeman. I just want to observe that, lucky us, we have a couple of legislators in our midst who can keep this conversation real and not speculative. They can tell us if they actually think unintended reputational harm should be part of a criminal conviction. But thank you for your answer and for your presentation.
Thank you, Mr. Cabeda. DA Sarback, thank you.
Thank you, Michael, for those questions. I think those are excellent questions to bring forward. And Mr. Freeman, thank you very much for being here. My name is Jonathan Sarback. I'm the district attorney here in Cumberland County. The question I had for you is that I know that we've sort of mentioned about other states, and this is not so much going into what you were talking about at the beginning of your presentation about the so-called punishment for reporting on crimes that were sealed, but this is sort of a procedural question I'm not sure you're going to be able to answer, but I'm going to ask you anyway, so I hope you understand. In Massachusetts, I know they've had people have been able to seal their records for a number of years. I got my start down in Massachusetts as a prosecutor in 2007, and they were sealing cases, or people were able to seal their criminal history back then. I don't know what the mechanics were of it because the district attorney's office down there didn't have much to do with it. It was judicial discretion. Do you know if there are mechanisms in other states where members of the press or anybody would be able to either petition the judiciary or ask the question to see what's underneath that seal? I know in Massachusetts, it's not an expungement, but just simply a sealing of the criminal record. And have you seen things in Massachusetts or any other state where the press would still have the ability to see what's under that seal by either petitioning the judiciary or some other mechanism that you might be aware of?
Yeah. No, the answer is I don't know. And the reason I think I don't know is that generally speaking, as I mentioned earlier, the press doesn't need to go back to the court system to get these records because it has the records already from the time in which the trial or the guilty finding was made. So that's why I say, not only don't I know, perhaps because of that reason, but that's why it's really ineffective, because it'll already be on Google. It'll already be in the archives of the New York Times, the paper that I worked for. So we don't need 5 years later to go back to the court system to get the documents. The only instance would be really in the case of a politician or someone like that who became interesting, but whose trial was so uninteresting and ordinary back when, because the person hadn't, been a public figure at that time, that it never got into Google or the newspapers, which is, rare, but I mean, and that certainly would be possible. But that's why I think that the media hasn't been that involved, is because they have the information anyhow. So the only part of this that really would be of practical effect is that last paragraph I started out with that would then punish them, at least possibly the way I read it, if they disseminated the information, regardless of how they got it, and assuming it was in their archives to begin with. Of course, with Google, everything seems to be in a public archive already. So that's why it seems to me this is very ineffective.
Thank you for your help. I appreciate it.
That's the best I can give you, sir. Sorry.
Anyone else want to chime in with a comment or ask Mr. Freeman a question? We very much appreciate your presentation today, Mr. Freeman, and hope that you'll be available for this committee if it has any questions.
Representative Ross, I think there were two other questions.
Oh, good.
Anthony raised his hand before I did.
I can't see that, so I appreciate you bringing that. I can't see it, unfortunately. Please proceed.
It's actually Foster.
I'm sorry. It's the name of I'm sorry. I'm just reading the name that Zoom's attached to that person. It must be the jail's administrator's name. I apologize.
No worries. Foster is the president of the NAACP. Would you like to continue, Mr. Bates?
Yes. Thank you, everyone, for having me, Madam Speaker, Representative Rachel Talbot Ross. I just have a couple comments here that I'd like to bring up. First, I'd like to say there are not many people being released from penal institutions across the country that's going to run for the President of the United States of America. If that was the case, I think their criminal records would be fair game if that was the case, but that's just not reality. Secondly, if we are to pass laws that are not going to be fair and reasonable to allow those who are being released from penal institutions across the country how are they supposed to reintegrate back into society and receive a fair opportunity if everyone has access to their prior convictions? When we look at prior convictions, if people can go back 5, 6, 7, 8 years, then we're not giving those who are being released from prison any opportunity at all to become productive citizens. So I would think that there's something in the bill itself that provides those people that opportunity. And when we look at these laws that are restrictive, we have laws that say that your record can be sealed 5, 6, 7 years after conviction. How is that helpful? So when you mention laws from 1986 and late 70s, we're in the 21st century. I think we should start looking forward and provide laws that are helpful for those who are being released, opposed to continuously holding those convictions over their heads. I agree there are some employees that should have that information. Other employees should not. Just to have it doesn't help us. So my question is, don't you think we should move beyond those recent laws, although they're landmark decisions? Don't you think it's time to change some of those laws to fit what we have going on today as far as criminal justice reform?
I mean, I think the answer I would give is that even though the Supreme Court decided those cases in the 80s and 90s, those cases have been followed by courts all over the country since then. I mean, both because they're, after all, precedent, which is what our legal system is based on, but also because I think they find them to be reasonable and well-meaning, obviously, and still relevant today. Obviously, if a legislature decides that's wrong, they can, as you are, pass legislation to the contrary, and then I guess ultimately it's up to the courts to decide whether that is consistent with our Constitution. That's the way the system works. I just haven't seen anything to indicate that these cases about the presumption of the openness of the legal system, the criminal system, or the presumption in allowing people to speak and disseminate truthful, newsworthy information. I don't see anything in the more recent past that would overturn or overcome the burdens and the balances that the Supreme Court set forth in those cases. And in fact, I think the arrival of the internet, although certainly problematic in a lot of ways in terms of disinformation and the like, I think in this area is an added problem that this bill has, because the information is already out there, and to somehow put it back in the box, I think is well nigh impossible.
Last point. So do you think it's fair and reasonable someone who's going for a construction job and it was a prior conviction of, let's say, burglary? Do you think it's reasonable for that particular portion of his record to be made known to the public that this guy was convicted of burglary charge, but now he's working in construction?
That's a good question. And, my personal answer really is not terribly relevant, I'm afraid. And I don't know what I really think. I think it's a hard question. Let's put it that way. And I'm not sure which way I would come out. But what I'm talking about is a somewhat ultimately different question about whether there isn't a right to at least express that information. Maybe a decision shouldn't be based upon it, but and that maybe is a bad thing. Presumably you interview the person and you can decide based on the interview whether he has overcome the disadvantage you might see in his resume if you knew of that. So that's not to say you won't employ them. I think a law that would say you can't employ such people, that would be severely problematic. But it gives the employer the choice, but at least it gives them all the knowledge. I mean, that's what the application process is for. And to totally just have something that occurred in history disappear, I think is very, very problematic.
Thank you, Mr. Bates. Thank you, Mr. Freeman. We're going to turn to Mr. Morgan, and this will be our last question for Mr. Freeman, and then we'll move on. Thank you.
Thank you, Representative Ross. My name is Matt Morgan. I'm a representative from the Maine Criminal Association of Defense Lawyers. I am a criminal defense lawyer. Thank you for the presentation, Mr. Friedman. I have just two questions kind of on what I'll call like the Google effect. I've heard this brought up before, essentially the idea that sealing laws are ineffective because this information already is going to be found online. You've brought that up a couple times. One thing I want to just clarify up front, you've kind of referred to the media collectively as we, and said that we already have that information. You're talking about, I assume, high profile cases. You're not suggesting the Times or local papers here in Maine, here in Maine are essentially archiving criminal data as it becomes available, right? That you're aware of.
No, right. I'm
Yeah.
talking about anything that would be in the paper or would be of the type that might be in the paper until an editor looked at it. And I can't speak to what proportion of cases that would cover, but usually papers do get many, the news of many criminal convictions. They might not always publish it, but it might well be in their archive.
Okay. And then my second question, just following up on that, is, I mean, you've essentially indicated you believe a sealing law would be ineffective for that reason. Is that based on sort of anecdote, or are you aware of studies or other information to support the idea that sealing is ineffective because employers will simply resort to searching for things online?
I don't know of any studies, but I've read about it because in Europe, they do have a series of kind of privacy laws where you can expunge these sort of things. And whenever there's a case like that, kind of a right to disappear, so to speak, that news, that information, and I read articles, I mean, those articles generally say how easy it is here in the States and around the world, actually, because of the internet, to get that sort of information. In Europe, in some European country, they've decided to really take overwhelming action, not only in terms of criminal convictions, but in terms of any news that was about a person that the person claims now is a private right that somehow is hindering them, and you can be guilty for publishing that. We say that's totally against our Constitution and just not something that would even be startable here in the U.S. So I'm kind of referring to that in general, but no, I don't know of specific studies.
All right, thank
No,
you.
sir.
Thank you. Mr. Freeman, it does look like we have one more question before we move on, and it's from Emma Halas O'Connor. If you'd like to join the conversation. Thank you.
Thank you, Representative Talbot-Ross. Thank you, Mr. Freeman, for your presentation. I guess this is more of a question for Representative Talbot-Ross and others on the committee who were involved in crafting LD 1459. I just wasn't sure whether it was the intent of the bill in that section 2 that people outside of the agencies that hold this information would be liable if they disseminate information. In other words, if a newspaper, has something in their archives, and since that story was archived, the record has been sealed or expunged or whatever we ended up with. If something about that person becomes newsworthy and the newspaper is circulating that story again, was it the intent of the bill that there should be some mechanism to prevent a newspaper from doing that, or that the newspaper would be liable if they did that? That wasn't my understanding reading the bill, but Mr. Freeman had a different understanding, so I wanted to understand that better.
So that is still up for some debate. I did not, it was not the intention, I think, is the way Mr. Freeman had interpreted it either. But clearly we've got some work to do if that's how he read that. But that was not the intention. From my perspective, that was not the intention. Others may be able to weigh in who were helpful. Members of this committee, many members of this committee helped craft that language from last session. So we can certainly get comment as we move on. We are going to talk specifically about this bill later on in the agenda. And so we can break it down at that time as well. If that'll work, Ms. O'Connor.
Thank you.
Thank you. Representative Harmonette, did you want to weigh in before we move on?
Thank you, Representative Talbot Ross, and good afternoon. My name is Tom Harnett. I represent House District 83, which is the city of Gardner and the town of Farmingdale. And thank you very much for your presentation, Mr. Freeman. I am a lawyer by background, so the Constitution is a pretty important thing to me. But I did just want to follow up on comments made by Mr. Foster Bates and Mr. Michael Kebeda. From a legislative perspective, and I can only speak for me, not all of the co-sponsors on the bill or other people that support this type of legislation. The goal here for me is to craft a policy whereby persons who make mistakes, sometimes very serious mistakes in their life, are not punished for a lifetime, that not every sentence imposed by a court results in a permanent scarlet letter on one's head, leaving no shot for redemption. As you pointed out, difficulty in finding housing, difficulty in finding employment, difficulty in getting loans to secure an education. That's what we're trying to do. We're trying to craft a policy. We obviously know we have to craft that policy within the confines of, constitutional limitations. So I thank you for that analysis, but I don't want us to lose sight of what it is we are trying to accomplish. And as a legislator, that's the policy that we're trying to bring forward. We just want to find the vehicle that makes it work. So,
the only answer I'd have there are that some states, and I don't know which exactly, I know New York has added discrimination on the count of arrest records, together with all the usual forms of discrimination, race, sex, gender, religion, what have you. I don't know how effective that is, but it does preclude you from making a decision based on arrest record. Now, how anyone's going to decide what the decision was based on is a different question. I don't know how that works. I do know that you can't ask that question in the application process about whether you were ever arrested. I think you can ask in New York whether you were found guilty of a crime, but you can't ask whether you were arrested because that would be against that discrimination law, discrimination of arrest records. So I don't know if that's an avenue to follow. I think also some states have kind of a certificate of good standing that you actually get a piece of paper after you've served your time that you can use to basically say that this person has fulfilled all their responsibilities after the conviction and that they should be given a clean bill of health or whatever it says, something along, I think it's called a good, good certificate or something like that. And to the extent that helps, maybe that does something. It might not go as far as you'd wish, but at least those are two avenues that I know are out there apart from the squashing of information, which is far more sensitive.
Thank you for that. And those sound like, things directed at the Maine Human Rights Act or, civil rights law as it relates to employment. I guess it could relate to housing and education.
Exactly.
As well, but that's a different tack than obviously the one we're putting forward, but I appreciate it. Thank you.
Thank you, Representative Harnett. And just for Mr. Freeman's information, the state of Maine did pass this year a bill that's commonly referred to as ban the box. And so we, from both private and public employers, we no longer have, as part of the application, the question if you've ever been convicted of a crime, just sort of for your edification. So. I want to thank you. I think that's all the questions for you. I want to thank you once again, Mr. Freeman, for your presentation. And again, say that we may want to talk with you again before this process is over. So this may not be the last time that we
okay, be happy to. And I really appreciate the opportunity that you all have given me. And I love Maine, have been there often. So I appreciate this slight connection. Thank you very much.
Thank you. So committee members, we are going to move on to number 2 on our agenda, the public and private criminal history record information in Maine. We have several folks who are going to help us understand this better. Catherine Moore, who's the Register of Probate for Lincoln County, District Attorney Sarbeck, and Ann Jordan with the Maine Judicial Branch, Bill Ward, who is with the Center for Juvenile Policy and Law, and then our own Jane Alberton from the Office of Policy and Legal Analysis, and Peggy Wright from Office of Policy and Legal Analysis. If the best way to do this is just start with Ms. Moore and go through in order. Does that make sense, Jane? Good. So Catherine Moore, if you want to, I don't know if you'd like to introduce yourself and then proceed with the presentation, but
Sure.
please do so.
Can you hear me?
Yes.
Good afternoon. Thank you, Representative Talbot Ross, and good afternoon, committee members. My name is Catherine Moore. I am the Register of Probate for Lincoln County, Register for 7 years, currently in the Office of Probate for 15 years. And I'm here on behalf of the Maine Association Registers of Probate. I submitted a memorandum dated November 9th. I'm going to be brief. Yes, it would be important for the probate courts to continue to have access to criminal history record information. Some of the things outlined, probate courts routinely get history records for all nominees for guardianships and conservatorships, for adults and minors, and also for name changes of adults. And if something shows up in their records, the judge may ask the person about any criminal convictions. We do notify as a group when we do an adult name change, the State Bureau of Identification, that an individual has changed their name so their criminal record can be updated. In adoption proceedings, we do a fingerprint background. Something more comes up with that, then the judge may ask DHS to do a home study or have the adopting parents in for questioning on their refindings. And the last question being is that we want to make sure that if we're placing a minor or a respondent in the hands of someone, that they are not been convicted of a sexual abuse or a sexual assault crime. And open for any questions.
I am not seeing any. Thank you very, very much for that information. And we can go to the district attorney if you're, we can also keep questions present to the end as well, but thank you. District attorney.
All right, sorry. Thank you, Representative Talbot Ross. Jonathan Sarbeck again, Cumberland County District Attorney. I'm going to be presenting today with Ann Jordan. Ann, I think, has a much longer institutional knowledge when it comes to this legislation, but this is about the sealing. From speaking to my colleagues about this law, it's Title 15, I think Chapter 310. This was a law that was put in place that would allow a person with a conviction, I believe it was for misdemeanors involving things like drug possessions or theft cases, that were within a I believe, if you could demonstrate that you had not gotten any convictions within 5 years, you could petition the court in a manner that would allow the court to basically make the call of whether or not they're going to seal that conviction. From speaking to my colleagues, the district attorney's office didn't have much to do with the provisions or a yes or no, a thumbs up, thumbs down type of situation. It was really up to an individual to petition the court and receive that from that sealing from the court. As I believe the materials were passed out with regards to how often this was used. You can see that it was, I would suggest, very rarely used, given the amounts of cases that come into the criminal justice system each year. I don't know if we have the specifics with regards to the types of convictions, looking at the types of convictions versus how many times it was used, but just, I mean, it's a handful. I don't think any district gets over close to a dozen that it was petitioned, and then looking at it whether or not it was allowed. So the law had it written into it that this would sunset, which obviously it did. So it is no longer on the books at this point, and we are exploring whether or not we should bring it back. So, Anne, do you have anything that you want to add?
Sure. This law was passed as a pilot project. It was limited to persons under the age of 21 for adult criminal class E convictions. As you can see by the materials that we presented in 2017, statewide, a total of 12 petitions were filed. 8 of those 12 were granted. In 2018, 13 petitions were filed. 6 were granted, 6 were denied, 1 was withdrawn. In 2019, 23 petitions were filed. 11 were granted, 11 were denied, and 1 was withdrawn. And in 2020, even after the law had sunsetted, 7 petitions were filed. 1 was granted, 3 were denied, and 3 are currently pending and scheduled for a hearing in late January in York County. I didn't review every single one of those files, but in reviewing many of the files, I can tell you some of the denials were based on the fact that the petitions were for felony crimes or for Class D offenses, which didn't qualify, or that the persons had had subsequent criminal convictions, which the particular statute specifically stated you could not have a subsequent either conviction or pending case or a case that had gone to deferred disposition and then was dismissed. The Maine Judicial Branch previously had a form published on the public website. It was designated as Form CR 2018 that an individual could just fill in and submit to the court. Maine has also for many years had a process for juveniles to request the sealing of their juvenile petitions, which is different and was than the newest bill that was just passed. We did some research, and during this last 10 years, there have only been 2 petitions filed statewide for sealing of juvenile convictions. So that's the information I have available to provide to the committee.
Thank you both. I have a question, and then we'll see if there are any other comments or questions. Just a personal question about the seemingly low number of petitions that are filed. My sense of that is it's a product that people don't know that they can, as opposed to there isn't a need. Do you have a sense of that, of the ways in which we have publicized, the ways in which we have communicated to individuals that a petition for that record was even available to them? Do you know how that may have happened, or who would be responsible for that, or how the public would even know that that bill was in effect?
There were I recall newspaper articles about the bill being passed, and the branch published the form that you could use to do that. However, the Maine Judicial Branch isn't allowed to give legal advice to individuals, and it would have been up to the individuals and or their counsel. I was surprised personally at the low number of juvenile petitions because under the old law, the juveniles should have been told about that opportunity by their counsel, in my personal opinion. In my prior life, before 2007, when I was in private practice, I indeed filed them on behalf of juveniles, and each of my juvenile clients knew about it. I only had 1 juvenile the whole time that I represented and was in private practice for 17 years. I only had 1 juvenile come back to me and say, I want to file this petition. So part of it is an education. I can't speak for criminal defense attorneys, legal service providers, or the district attorney's offices. It's not appropriate for me to speak to what they did or did not do in those situations.
Yeah, and Representative Talbot Ross, this came into law prior to me becoming the district attorney. But to be quite frank with you, when I was an assistant district attorney, I was not aware that this law was on the books. And I think that the numbers that you see reflect that the public really wasn't aware of this either. I don't like, as I said, from speaking to the other DAs who really, I think, had to kind of take a hands-off approach that this was on the judiciary. There really wasn't probably publication from our offices with regards to this. But I'm not sure when it came down to the defense bar, how much they knew and whether that was shared with people who had criminal convictions in the past. At the same time, though, I think that it might be difficult because these are past prior convictions. So I know we have some criminal defense attorneys on this that might be able to speak to this, but it would be probably very rare that an attorney might reach out to their client from 5 years ago and say, oh, by the way, this new law got passed. But maybe that's a step that we should all think about taking if we are to look back at a different type of, or adopting this law again.
Thank you. I would be interested in hearing from others as well. And because I don't know how many, under 21 years old would read the newspaper article and then find, some incentive and some motivation and even know where to start about filing this a petition. I think that's probably asking a lot.
Yeah. Representative Talbot Ross, yeah, I'm about to give my presentation, but I will just say that at least with respect to juveniles, the research that the USM report Unsealed Fate found that young people actually did not know. And even when counsel gave them the advice, 3 years post disposition of your adjudication, coming back when you're 21 or you're 19 or you're 22 was really highly impractical. And a lot of the sort of qualitative research, which was a component of that report. So I can at least offer that for the committee's consideration. And one of the recommendations of that report at the time was to have better information distributed to families and young people so that they understood what at least the juvenile code, which is different than this, but has a very similar structure as far as how you get a record sealed. And we, the center, USM, the Department of Corrections, we did have the judicial branch review it, did put together an informational brochure that defense attorneys could use that was distributed, at least I think, I'm not sure whether DA Sarbeck knows this, but I think at Cumberland County, Christine Tebow distributed a bunch of it. So there wasn't, so I'm just saying that was what we did. This is the copy of it, which says juvenile record in Maine, know the facts. And so there was an attempt to try to get the information out, at least around juvenile adjudications, because it was a similar finding that young people just didn't understand what the law was. So just I give that information, like we've lived this experience with the juvenile code a little bit as information for this group, and others may have more, but I just figured I'd jump in there with that.
Thank you, Ms. Ward. Thank you very much. I think we do have two other folks who have a comment or a question, and I'll just ask you again, if you haven't spoken, to introduce yourself, and I'll go to Courtney Allen and then Mr. Morgan.
Thank you, Representative Talbot Ross. Hello, my name is Courtney Allen. I'm the Policy Director of the Maine Recovery Advocacy Project. I just have a quick question, and I'm not sure who can answer this, but understanding that young folks are not applying for this opportunity, is there a way in a second reiteration of this law to make it an automatic process or an easier process for young people?
Courtney, I think that I don't know the actual answer to this, but I think that because of the low numbers, I think you make a good point that maybe we should explore that type of option for the legislation or some sort of mechanism to see if that's a possibility. Because I think the numbers speak for itself, like I said. And thank you, Jill, with regards to getting that information out, because I think it is important. If the new law didn't, if this proposal didn't have that automatic provision, I think that it would be something that we would really need to sort of get out or an education about this law, because otherwise we're going to be spending a lot of work on things that people aren't really going to see very often or petition for very often, I should say.
Yeah, just a quick follow-up, Representative Talbot Ross. I just think that if we're going to, like DA Starbuck just mentioned, if we're going to spend this much time and effort to ensure that young people have a second chance, that we also don't need to be spending the time and effort to educate them on how to do that. And if we just added a clause in the law that it was an automatic process, it would save a lot of time and ensure that the young people that need this get the opportunity to access it.
Thank you very much. Matthew Morgan?
Thank you, Representative Ross. Matthew Morgan again. I'm a local defense lawyer. We use this very, very infrequently. Clients never reach out about this. They ask about pardons when they ask anything in our office. I would say that part of it probably is that many people who would qualify for this are probably getting some kind of deferred disposition that might end in a dismissal, at least here in Kennebec County. But the people who aren't getting the benefit of this are people who are maybe picking up convictions that either don't get a court-appointed lawyer because they're not facing jail time or can't afford a private one if they aren't. And they just don't know about it, would be my guess. And I think either an automatic provision, which Courtney Allen mentioned is a great idea, or at a minimum, I think if people are going to be given information, it needs to be given to them at the point of conviction, because that's going to be the time when they actually care about it. And that's going to be a time when we have contact with them and we can hand them a piece of paper about this.
I'm just grateful that Ms. Allen raised the question around automatic, because it is something that we need to, as a committee, you know, we've heard about the challenges in an automatic sealing, but it is something that we have within our grasp to try to determine. So thank you for that. I think Foster Bates has, Foster.
Yes, definitely. Thank you.
Yes, please.
I just have a quick question. Can we bring awareness to those people who are in correctional facilities throughout the state about this law? Because I'm at Maine State Prison, and I don't think many people here are aware of this this law surrounding juveniles. Because we have people who was at the Juvenile Center in Portland who are here now have no idea about this law whatsoever. So is there any way that we can provide these guys with this information, this law?
That's a good question and a good segue. We can turn the discussion over to you, Ms. Ward, if you'd like, and talk about, it says juvenile records, and maybe bring folks up to date as to where we're at, if that seems like a good transition.
It does. I see Ann Jordan has her hand up. I didn't know if we wanted to do that first. Sorry if I'm messing up the protocol here.
No worries at all. Ann?
Thank you very much, Representative Talbot Ross. I just want to let you know that in anticipation of this question, I have asked OIT to determine if the new Odyssey criminal record system has the ability to do any kind of automatic sealing. They did not have the answer to that, but they were going to look into it and consult with Tyler Technologies on that. So I don't have a definitive answer for you, but I anticipated that question, so I've already sent it forward to our OIT. We do not have that ability in Megis right now, which is where the criminal records currently exist, but we're building the new Odyssey system, so I'm trying to find out what the process is there.
Great, thank you.
Okay, great. So hi, good afternoon, everybody. I'm Jill Ward, and I run the Maine Center for Juvenile Policy and Law in conjunction with the Juvenile Justice Clinic at the law school. And we were involved in an effort to improve the juvenile records code, bring it up to speed in this last legislative session in support of Representative Talbot Ross's legislation, which was LD 1676. And if I'm able to share my screen, which I don't know if I am, I do have a document here that I think will help us walk through some of the changes in that legislation. Am I able to do that? Let's find out. There we go. So let me just say as a point of context, this was a collaborative effort between many stakeholders to try to bring the code up to speed, and also in collaboration in conversations with the judicial branch and prior testimony that had been given around balancing this notion of juvenile record confidentiality with the victim and the public's right to know and public safety, and bringing the law in line with the digitization of the juvenile of the court record system that Ms. Jordan was referring to. So in all of these conversations, there was a task force that looked at transitioning Maine into the digital system. And one of the recommendations was this presumption of confidentiality of juvenile records, in part because, or in most part because of the purposes of the juvenile code, which are different from the adult criminal code. And so this legislation came from lots of conversations with lots of folks under the leadership of Representative Talbot Ross to do a couple of things. To update the records code, to bring the policy in line with the technology, as I just said, and to implement some best practices around juvenile records, and to do it in a timely manner so that as Odyssey and these other systems are coming online, that they have the capacity to do some of the things that I think are of interest here, including the automatic sealing of records, which is embodied in this new law, and we'll get to that provision in a moment. We also, with this bill, tried to reorganize the code to make it more clear for practitioners. It establishes a framework to make individualized determinations about when records around a court-involved youth are publicly accessible. It balances those interests, as I said before, between the purposes of the code and public safety and the right to know. And it tries to reduce the collateral consequences that we've heard about by allowing for the automatic post-adjudication sealing of juvenile records for very low-level offenses. So what I want to do, and I will provide this document to the commission after I just walk through it for everybody's information. This was presented at a training that the center, along with the Maine Prosecutors Association and the Maine State Juvenile Justice Advisory Group, put on a couple of months ago. And all of these changes we're talking about here are effective January 1st to give courts and others time to get forms and proper sort of protocols in place to be able to comply with the law. So it did not go into effect on October 18th, like a lot of statutes did. This one will be effective January 1. And what it does, first and foremost, in almost all of these changes, since the bill did reorganize the code into section 3308 of Title 15. And the Part A establishes a presumption that juvenile records start off generally confidential. And it bakes sort of this policy presumption in the law, and then sets up a rubric under which they become publicly accessible. So section C, 3308C, sets up a rubric in which certain records, juvenile records, are under certain circumstances always open to the public only by order, and the way the rubric is set up, either side can petition, or the press or anybody can petition to have something open that's closed. But they start off either presumptively opened or closed based on the level of crime and whether the juvenile is under age 13, because there's a competency question that comes into play there. So this is the rubric that is established under 3308C. And I'm not going to walk you through, you can see it there, and I will share the document. Some of the questions that come up about how this works in practice: the highest classification of the crime petition determines whether it's presumptively confidential or open. Again, juveniles petitions that are deemed open to public inspection may be inspected by any member of the public at the courthouse. Again, and this is consistent really with other New England states. And if you look at the Clearinghouse website, most other states, but certainly all the New England states, there is not electronic public access. They're not electronically accessible juvenile court records. And this is a pretty strong policy presumption when it comes to young people across the states, but certainly is true in New England. And so when things are publicly accessible, you still have to go to the courtroom and inspect them. There's not this emailing around. And what the policy goal with that was to not have, especially during an open case, information about a young person just being emailed around all over the place. So when a request is made to have a presumptively open petition made confidential, or a presumptively confidential petition be made open to public inspection, the hearing where the court, here are the factors that a court must consider, the purposes of the code. You can see the juvenile's interest in privacy, the alleged victim's interest, the nature of the crime. You carry, with respect to a bind over, the nature of the juvenile crime alleged, the characteristics of a juvenile and public safety concerns. And that's tied to the bind over statute when you have a very serious crime and there's a petition to bind a youth over into the adult system. Let's see, I think the other things to highlight here, if a juvenile petition is open to public inspection, the public may attend any juvenile court hearing on the petition and may inspect the order of adjudication. And unless proceedings are suspended for a competence determination, victims may be present. We try to take into consideration the victim's interest in the proceedings, but also, especially where competence was in question, to try to also protect the very young juvenile offenders' right to keep a lot of that information private. So below here is a summary of where the permissive sharing of juvenile case record information is contained in the revisions. Criminal justice agencies may share any information in juvenile case records for the purpose of administering juvenile criminal justice. Following adjudication of a juvenile crime, any information contained in a juvenile case record may be disseminated to persons who directly supervise or report to the health, behavior, or progress of the juvenile, school superintendents, criminal justice agencies such as DOC or DHHS, if relevant to and disseminated for purposes of creating the individualized plan for rehabilitation. Juvenile case record information, the possession of DOC may be disseminated to anyone with informed written consent of the juvenile or their guardian. The juvenile intelligence investigative record, JCCO records, and all of those types of records, which are distinct from juvenile case records, may be inspected, disclosed, or disseminated pursuant to court order, but the names must be of the victim or minors must be redacted. Before ordering disclosure, dissemination, or inspection of confidential juvenile case records, there must be notice, and the hearing shall consider the purposes of the code and the reasons for the request. With consent of the court and subject to reasonable limitations, redacted records may be made available to persons having a legitimate interest in the proceedings or conducting pertinent research. Again, that's a court determination. And then mandatory, there are examples here of when juvenile case records may be mandatorily shared. Those are in the code directly. And I'm not going to read through all of this. I will share that with you. I will say just in general, with respect to the way it was structured, we really, in talking through, we wanted to make certain that the court had the most discretion and that we tied additional changes that might occur to either changes in the statute or judicial record. So again, this presumption of confidentiality is sort of the upside down pyramid. It's broad and then it narrows based on exceptions that are either in place statutorily or that come to be in place through judicial rulemaking that are also consistent with the code. And And then I'm talking a lot, but the last thing I will share is the sealing provision, which is of interest in what we were just referring to. So current law with respect to, these are juvenile adjudications, is a juvenile can petition to have their record sealed if it's been 3 years since the disposition, they have no other crimes, they've committed no other offenses in that time, and they have no pending proceedings open, they can petition the court, and the court does a calculation to decide whether to grant the sealing. And what this provision does is retains that for class, this part of the bill retained it for class A, B, and C offenses, but for D and E and civil offenses, it automatically will seal the juvenile's record. There's some notice that has to be given depending on the status of the disposition, whether the young person is leaving Long Creek or whether they're on a community supervision situation, but there's a certain amount of time that's given to provide that notice. And then those records are automatically sealed, and it allows the juvenile to be able to answer questions around the record as if it did not happen. And it is important to note that courts and criminal justice agencies still have access, but it does not show up on a background check through the SBI process. And I will just pause there. That was a lot, and I will certainly send this summary document of the changes to the code. It was a pretty big reform, as you can all see, for you to all chew on.
It is a lot. I'm not seeing any hands or comments up. I will just say it is quite dense. It was a considerable amount of work, and I want to thank you for leading that work, Jill, along with a group of both prosecutors, defense attorneys, who all came together as a team, a collaborative team. And it took well over a year. It took quite a bit of time to put all of this together and then to get it into law. So it was a huge victory, and I want to thank you for that leadership. It may be best to get that information into committee members' hands so that we can have more discussion about it. But just to Ms. Allen's point before you started your presentation, and then to President Bates' point, this could be a model for us. There are pieces of this certainly that we can pick out and see how it would adapt to the adult system. I don't know, Courtney, if you had any response to it, but there are a number of protections in place. What is really, really, I think, in light of the presentation we had at the beginning of the meeting with Mr. Fried, what's really extraordinary about this law is it does balance public safety, right to know, and privacy. I mean, it has that balance in it. So I don't know if folks have any reaction to the presentation, or if you want to get a copy of that material and then we can revisit it. So seeing no, oh yeah, hi, Courtney, please.
Thanks, Representative Talbot Ross. My only reaction is pretty much what you just said. I wonder exactly what we can take from this, as the work's already been done, that goes into the adult system.
Yeah.
There's got to be a lot of in there that can be moved over.
I apologize, I did not send this document to you all ahead of time. I pulled it out of the training and I had to add the sealing portions, but I will forward that to Jane so that everybody has it.
I thank you for that, Ms. Ward, because it really does allow committee members to see the places in the system that we've been talking about confidential and sealing records, and not knowing and being able to actualize the option of an automatic. So we've been talking only about the petition, the mechanism around petitioning, and we've seen where that gets to be problematic if a public doesn't know about it. So this provides us with some other models and some other mechanisms. So we'll get that to committee members as soon as possible. Any other comments? Oh, Mr. Bates, please.
I'm not sure if I heard the response to, or she had elaborated on, she made a comment about the circumstances in which a conviction, juvenile conviction, can be open or disclosed from confidentiality. What circumstances would there be to dispose it from confidentiality?
So when a case is pending against a juvenile, and this is a juvenile adjudication, not an adult adjudication, although there's criteria for the court to consider with the bind over also, but when the request is made to have if you have, let's say, a manslaughter charge that's presumptively open, but it's maybe a 14-year-old and there are all these circumstances and their defense attorney wants to petition to have it closed, they have to look at the purposes, the court has to look at the purposes of the code, the juvenile's interest in privacy, the alleged victim's interest, the nature of the crime, and the characteristics and public safety concerns. And the court could decide to close something that's generally open or not. And then with cases that are presumptively confidential, a prosecutor or someone else could petition and say, I think this needs to be open. I think this is a big public safety concern. And then the court looks at that same rubric and makes a balancing determination about whether to make something that is presumed closed from the beginning or confidential, then open. And that was that chart. So I will forward that so you can take a look at it. But the things that the court has to consider, generally speaking, are the purposes of the juvenile code, which are much more rehabilitative than the adult criminal code in its structure. And then the juvenile's interest in privacy, the victim's interest in privacy, and then this public safety interest and the characteristics of the juvenile. Are they very young? Do they have diminished capacity? Maybe they weren't found incompetent, but maybe there's some other factors like trauma and other kinds of things that a court could consider in their equation as to whether to make something that is presumptively closed open or presumptively open closed. I don't know if that made it more confusing or less. It is a complex rubric, but it is sort of trying to exact that balance and have all of the principles around individualization and the purposes, the rehabilitative purposes of the code be its foundation.
Okay, thank you.
Sure.
Which I would just say is pretty amazing when you think about it, because that's baked into the juvenile code. And maybe a question for this committee is, what is its application? That same kind of criteria built into the criminal code. Should that be the same stream of consciousness? All of that. So committee members can weigh in on that at some point. So seeing no other comment, I want to welcome Representative Pickett. We know that you had to join us late, but welcome. It's good to see you. And we will move on. Jane Overton with a discussion about the carried over and pending legislation regarding confidentiality or use of criminal history record information. We wanted the committee members to know all of the vehicles that will be debated in the second regular term for the 131st, which starts in January. So Jane, if you'd like to lead us in that conversation, thank you.
Sure. Mine's real nice and short. You'll appreciate that. I brought up the memo, but it's also in your packet. There are a number of bills that are carried over that might be of interest to you, and also a number of bills expected. We have less information about them than some of the bills that are carried over. LD 463 is a concept draft regarding helping people to obtain housing. It's in Labor and Housing Committee, and I don't know anything more about it than that. And it's carried over. Other carryovers include LD 465, which is also a concept draft regarding labor and housing in that same committee and carried over. Then LD 473 is an act to create the Maine Rental Assistance and Voucher Guarantee Program. That bill is carried over on the appropriations table. I think that's where it is, right? Yeah, it's on the appropriations table. And as it appeared eventually on the table, it requires a landlord who is participating in Maine Rental Assistance Guarantee Program to agree not to consider the tenant's criminal record, credit score, or rental history in renting to tenants. LD 1310 is carried over in the Judiciary Committee. That's the one that we have talked about as being available to the committee next year. And they could use, you know, they might be interested in some of the work you do, or they also can report out a bill on their own. So I don't know if they would use 1310 or not. Then there are some legislative requests that were approved for introduction in the second regular session. These have an LR number, which is legislative request, and LR 2498 is a resolve directing the Maine Human Rights Commission to extend its pilot program to investigate and report on incidents of harassment due to housing status, lack of employment, and other issues. As far as I know, that bill is not written yet, so that's all the information that I have. LR, that's legislative request 2503. The first one was sponsored by Representative Talbot Ross, so is the second. And the second one is an act to increase opportunities in the cannabis industry by removing restrictions related to certain convictions for drug offenses. I have not seen a draft of that bill yet. LR 2508 is also a bill from Representative Talbot Ross, and it's an act to continue the work of the Criminal Records Review Committee. In case you've forgotten the name, that's your committee, you're on it. And the last one is, there is a potential for some legislation from Resolve 2021, Chapter 75. This Chapter 75 directs the Maine State Housing Authority to examine, in collaboration with stakeholders, fair chance housing policies considered or adopted in other jurisdictions, addressing housing issues for formerly incarcerated persons and expanding housing opportunities without creating an excessive burden on housing providers. So this is already passed as a resolve. It directs the Housing Authority to report to the Labor and Housing Committee and authorizes that committee to report out legislation. So there are a number of bills that we know are before the legislature for the second regular session. Those are the carried over ones. And then we assume that the ones approved for introduction may come. And then there is the report due on the Maine State Housing Authority on fair chance housing policies. That's all I have.
That's great. Any questions from the committee? I will simply point out that LR 2508 again continues the work of this committee. So we'll be able to hopefully, if you agree that it's necessary, we will be able to continue our work as many of these matters may take months to come to some consensus, but also just months to understand its impact and how we can address them. So LR 2508 will do that. And then I'll just, the LD, it's LD 1201 that gave the authority for the Maine State Housing Authority to look at fair chance in housing. That's currently taking place now. Any questions about the pending legislation? The bottom line is we have a couple of vehicles in order to get our work done. So we should not, that should not hamper us taking a step forward in the next legislative term. Seeing no questions for Ms. Overton, we'll change to turn it over to Ms. Reich, and she's going to talk about sealing criminal history records under the formal Title 15. This is a discussion about 1459, LD 1459, that Mr. Freeman started out talking about. We're going to do a deeper dive into that as a possible way to move this committee's work forward. So turn it over to you, Peggy.
Great, thank you very much. I'm going to go ahead and share my screen. You have this in your packet. It is what we call a side-by-side. It compares the law that was sunsetted in 2019. Turned out it was a pilot project. I'm not sure people, when they enacted it, thought it was going to be a pilot project. I think they might have thought it was a first step, but because it's sunsetted, we're still looking at it as how it worked. The next column is LD 1459, which Representative Talbot Ross sponsored. It was printed in the first regular session. Technically, this bill was voted on not to pass by the Judiciary Committee because this study committee was being created, recognizing that the study committee would be able to put forward either this bill or some other version, and the Judiciary Committee would be able to move forward with that. And so what I'm going to try to do, I usually talk really fast, so slow me down if I get going too fast. What I'm trying to do here is compare what was proposed in LD 1459, that's Chapter 310A, with what was on the books. And you saw that Ann Jordan had listed the numbers of petitions that had been filed under that. So I kind of designed this document as trying to be a one-stop shop for all your information about the old sealing bill and the proposed sealing bill. So I've thrown in the definitions that this bill cross-references. So administration of criminal justice. A lot of this relies on the Criminal History Record Information Act, which, if you remember, Laura Eustack went over in detail at the last meeting about what is criminal history record information and how much of that information is confidential. Maine is different from other states in that a lot of that information that's part of somebody's criminal history record is not public going forward. So we kind of graft onto the Criminal History Record Information Act. So the definition of administration of criminal justice, another jurisdiction, criminal history record information. I just copied that, which you already talked about last time, so hopefully we don't need to talk about it again. What a criminal justice agency is, and that's going to be important as we talk later about who can share information. What dissemination means. It's really transmission of information by any means, orally, in writing, electronically, and it's by or to anyone outside of the criminal justice agency that maintains that information. So here's the big change, the eligible criminal conviction. In Chapter 310, the original law, the only thing that was eligible to be sealed was a Class E crime, except for anything under Title 17A, Chapter 11, which is the sexual assaults chapter. Under Chapter 459, Representative Talbot Ross and the whole group that had been working on this said, let's expand that beyond Class E crimes, and instead included Class D crimes, but also listed several that were going to be not eligible. So those things that are not eligible are a conviction under Chapter 11, again, or Chapter 12, which is sexual exploitation of minors, or 852, 853, or 855. So aggravated sex trafficking, and patronizing prostitution of a minor or a person with mental disability. Even though some of those are Class D crimes, they are not eligible for sealing under LD 1459. A conviction for stalking, under section 2010A or 2010C, not eligible for sealing. And unless a sentence has been commuted, and remember, the only person who can commute a sentence is the governor, any conviction involving a crime of domestic violence or any crime involving domestic violence. And it uses a definition in Title 15 for what is a crime of domestic violence. And it specifically lists crimes of domestic violence, a crime of domestic violence, assault, domestic violence, criminal threatening, domestic violence, terrorizing, domestic violence, stalking, or reckless, domestic violence, reckless conduct. It also includes a violation of a protection order or protection from abuse orders in Title 19A, in which the alleged victim is a family or household member. And this next square is definition of family or household member from Title 19A. So I'm just going to zip through that. So also ineligible under LD 1459, if 20 years have not passed, a crime against a family or a household member, regardless of whether the relationship was an element of that crime. So any crime against a family or household member. And again, if 20 years have not passed since the judgment of conviction was entered, a violation of a condition of release pursuant to 1092 committed while the defendant is released on pre-conviction or post-conviction bail for a charge that involves a crime against a family or a household member. So same situation, the crime against family or household member, or if there was bail or post-conviction release, if the underlying charge was against a family or a household member. And then paragraph F, this is not eligible for sealing under 1459, a violation of a protective order. We have several kinds of protective orders in our statutes. Title 15 is protective orders and crimes between family members. So an actual crime has to be involved in that. Protection from harassment orders. 506B is a violation of a protective order that it cross-references the other protective orders that are listed here. Section 4011 subsection 3, this is a warrantless arrest for criminal violation of a protection from abuse order. We might want to talk about how that fits in here. I'm not sure, somebody will have to instruct me on that. And the required arrest by a law enforcement officer when a criminal violation under section 4011. So these are all about, there's a protection order issued against the defendant and the defendant violates it. Those are that's something, and they've been convicted of that. That is a conviction that is not sealable under LD 1459. And then paragraph G is a conviction for cruelty to animals. So if there's a conviction, not eligible, that crime is not eligible. So that's the category of crimes that could be sealed under 1459. And you can see that that is there, although it broadens, 1459 broadens it to include Class D crimes, it also has very specific exemptions that where it doesn't apply to either Class D or Class E crimes. And then section 2262, these are special restrictions on applying. So we just talked about what's an eligible criminal conviction. And as Ms. Jordan also mentioned, was at the time of the commission of the crime, underlying the eligible criminal conviction, this was under the old law that was sunsetted, the person was at least 18 years of age, but had not reached 21 years of age. So the purpose of that was kind of somebody who's young, still counted as an adult, they made a mistake, let's give them an opportunity to seal their record. LD 1459 doesn't have that age limitation. It's the crime limitation, what those crimes are, and then going forward, it's the time limit, the time that has elapsed since the conviction. So both of these are based on 4 years. At least 4 years have passed since the person has fully satisfied each of the sentencing alternatives. Imprisonment, incarceration, restitution, community service, whatever was part of the sentence, that has to be completed. And after that's completed, 4 years later, that person is eligible to apply to have that conviction sealed. Also, the person can't have any other criminal violation in this state, has not had a criminal charge dismissed because of deferred disposition. And I think that's it. And then the person also, at the time that they're applying to have their conviction sealed, can have no criminal convictions from another jurisdiction. Anytime, actually. At the time they're applying, there has to have been no other criminal conviction. And the person has no pending criminal charges in this state as well. So if the person meets all those prerequisites to filing the petition, then they can go forward and file. It's a petition, but it's actually a motion in the underlying criminal case. So they go to the court where they were convicted, at least 4 years before. It's going to be more than 4 years because all their sentencing alternatives have to have been completed. They go to that court and they file a petition. I'm assuming it would be the same type of form that the judicial branch had prepared for Chapter 1310. So it's up to the person to file the motion to request the sealing. This is not an automatic system. It's a petition-based system. The motion must be filed in the underlying criminal proceeding, and the judicial branch created a form in the past. They will probably excuse me, create a forms, because that is the best way to get somebody to provide all the information at one time. Pardon me. So once the motion is filed, the clerk schedules a hearing before the court. So there has to be a hearing before the judge. It's not really clear who gets notice of the hearing. The person has a right to have an attorney, but the state will not pay for an attorney. So it doesn't fall under the Indigent Legal Services Commission. The state can be represented by the district attorney's office that handled the underlying conviction. But on a case-by-case basis, a different prosecutory office could represent the state. And it could be that the state doesn't even want to weigh in on it. The Maine rules of evidence do not apply. The idea is to make this a really accessible, easy proceeding. The court is allowed to admit reliable hearsay evidence. So that's one of the reasons why the rules of evidence don't apply. It's still up to the court what is admissible, though. After the hearing, if the court determines that the person meets all the requirements, they go over all the requirements, which is why that form is really helpful too. The court shall find that the person is entitled to the sealing action, and the court issues an order stating that. And so this is a place where we might want to refine this law if you're going to go forward about how this works and how that order is communicated to SBI and other criminal justice agencies. But if the court finds that the person does not meet the requirements, then the court must deny the motion. So the court really doesn't have any discretion under LD 1459. I think it's the same under the old law that was sunsetted. If the person meets the requirements, then the order is issued. If the person does not meet the requirements, then the order is not issued. In either case, the court must include written findings of the facts supporting whichever the determination is. So if the court seals the record, says, yes, we're going to seal this conviction, the court sends that order certifying the determination to the State Bureau of Identification, and the State Bureau of Identification must change its records accordingly to not release the information of that conviction. And here's this little asterisk. we recognize that the law that Jill Ward just talked about, the juvenile sealing law, requires the court to send an order to SBI, and that's kind of it's a little bit clunky. There can be an easier way to do this electronically without a physical order being transmitted from the court to the SBI. Something we can work on. Also the SBI sends a notice of compliance with the requirement to the person who just got that order, to the person's last known address. The next subsection, I believe it's exactly the same as the original sealing law, is about if the person, after their record is sealed, they commit and are convicted of a new crime. And this law requires them to notify the court. If they don't notify the court and the court finds out, the court brings them back in. The court holds a hearing to determine whether or not the person actually does have a new conviction, because that new conviction means the sealing gets undone and the sealing is lost. SBI will go back to sharing that information, and those restrictions on sharing the information will not apply. That's a whole lot of information about how you go through all that. And there's the notice to the SBI about the new crime. So 2265 might be kind of the heart of this, which is, it says, if your record is sealed, here are the limitations on who can actually receive that information that's sealed. Sealing it basically makes it confidential criminal history record information. Doesn't really say that right here, but it does say it's confidential. Notwithstanding the Criminal History Record Information Act, this conviction information is confidential. And a criminal justice agency may not share that information except with the person whose record is sealed. That's one. Another criminal justice agency, they always have access to that for the purposes of the administration of criminal justice, as well as criminal justice agency employment. I don't know what other reason a criminal justice agency would be trying to access that record, but if they come up with another reason, they're not supposed to have access to it. So that's a description of those purposes. It's also available to the Secretary of State to ensure compliance with federal motor vehicle law. So again, this is for a particular purpose. It can't be given to the Secretary of State's office for any other reason. And it's available to the victims or the family of the victims. And then to the Office of Security. So this is something that was actually negotiated in the Judiciary Committee when this was discussed in the 129th legislature. And it's to the Office of Securities. Judith Shaw spoke to you last meeting about their need to use this information because of the federal laws that require access to this information. And to financial institutions. And it's to a financial institution if the financial institution is required by federal or state law or rules to conduct a criminal history record check for either an employee position or for a prospective board member. If the federal law or the state law requires it, then the financial institution can have access to the information for that purpose. And of course, if the court orders that the information is available, then it can be shared with it. The court has to find good cause to share it with whoever it is that's going to receive it. Good cause includes a finding that access to the criminal history record information may be necessary for the determination of any issue before the court. That might be a place where you want to be a little more specific about that. So a person who has their record sealed under this, just like under the old law, is entitled to respond to inquiries from other than criminal justice agencies by not disclosing the existence of that conviction without being subject to any sanctions. And then a person who intentionally disseminates criminal history record information relating to a criminal conviction in violation of 2265. That was the one that said you can't share this except for these purposes, knowing that sharing that information is in violation of the law, is guilty of unlawful dissemination as provided in Title 16, Section 707. We're going to get to that at the end of this. And then the next piece is an appeal. A final judgment entered under 2264, subsection 5 or 7, which says the person either is or is not eligible to have their record sealed, and the court either seals it or does not seal it, may be reviewed by the Supreme Judicial Court. So number 1, subsection 1 is the person who asked to have their record sealed and the court said no. The person can ask, actually it's any person who's aggrieved by the final judgment, can go to the Supreme Court, can file an appeal with the Supreme Judicial Court. The Supreme Judicial Court is not required to take that appeal. If it's the state that appeals, and I'm assuming the state is appealing because the record is sealed in either case, the state has a right to appeal and the Attorney General is not required to weigh in before the appeal is filed. Like most appeals, the Attorney General is supposed to kind of be the gate for whether or not things go to the Supreme Court from a state prosecution. In this case, it is an appeal of right, so the Supreme Judicial Court would have to hear that appeal. And then the very last thing, and this is what Mr. Freeman talked about, this is an amendment to the Criminal History Record Information Act. It's Title 16, Section 707, which currently says a person is guilty of unlawful dissemination of confidential criminal history record information if the person, again, intentionally disseminates confidential criminal history information, knowing it to be in violation of any of the provisions of this chapter, or if the person intentionally disseminates criminal history record information relating to a criminal conviction in violation of, this would be 2265, knowing it to be in violation. This bill adds to that, other than a person receiving confidential criminal history record information pursuant to 2265, subsection 4. That's the one that gives the information to the victim or the victim's family or agent. So my understanding about this violation is that because this is in the Criminal History Record Information Act, and the Criminal History Record Information Act applies to criminal justice agencies, this violation is really, at least the legislative intent, or the Criminal Law Advisory Commission, which had put together this rewrite of the Criminal History Record Information Act, was really focusing on criminal justice agencies and them abiding by the limitations of this statute. So it was really focused on anybody in a criminal justice agency who has access to confidential criminal history record information. And knowing that it's confidential and knowing that it would be in violation of the statute, they go ahead and release it. So I think that's the focus of it. I don't know that that the legislature has said, oh, this applies to anybody out there who already has the information. And so I completely understand Mr. Freeman's concern about being consistent with the Constitution and what the US Supreme Court has said. We will definitely look at this, but I'm not sure that this was ever intended to apply to newspapers or Google or any other entity who is not already covered by the Criminal History Record Information Act. But that's something we will definitely look at. Okay, that was fast. I'm going to stop sharing, but we can jump back in anytime.
It is a lot of information, Thank you very, very much, Ms. French. And also, I wondered if we could just, if anyone has any immediate comments or questions, because I'm wondering if we can circle back to Jill Ward if Jill, you're here, that last piece and what Mr. Freeman was talking about this morning, Emma's question this morning, Emma's question earlier this afternoon, and it has to do with liability for the dissemination of this, knowingly disseminating this information that has been deemed confidential. So if Emma is still with us, I'm just wondering, as a way for us to think about this, Jill, if you can talk to us about how we thought about this within the juvenile, the dissemination of a juvenile record.
Right. So I appreciate you raising it because I went so quickly. It was the last piece that I didn't mention, but it is in the document I just forwarded. So the bill did, our discussion at the time of making these changes was around what we were trying to do was not have either another kid who might have been the victim of an offense or a family member who might have access to the information. We wanted to disincentivize the sharing of it in sort of an emotional and harmful manner, because that's often the case in these situations. And then there was also the desire to have some disincentive too, for those who might mine the information if it gets put out there. And, there are a couple of very strong anecdotal individual cases where a young person was sort of vilified on social media and a whole blog was made out of the incident. And even though the court case was the court information was made confidential because people had access to it and put it out there anyway, who were present, it didn't sort of matter. And so we were trying to just create, it's a very high standard, it's a knowing standard. But we really did want to create some mechanism so that, for instance, prosecutors could inform victims, this stuff is confidential and you're mad or you're upset or you're grieved, but you really can't be sharing this because this is against sort of what the current law says. And so this was sort of the conversation. How did we create some balance so that there was some teeth to the statute, in the sense that people couldn't just ignore it? They couldn't just, if they had some sort of access to it. I mean, I don't think we ever really thought, although it does do this as well, that we were worried about state actors improperly sharing things, but it could apply in that case as well. So just really trying to have some actual penalty for doing this, because once the information's out, the harm, you can't really take the harm back. Once that information is public, or a media outlet gets it, or it's on social media with kids, that's very common. So we were trying to strike that balance there too. So I think, is that helpful? That was sort of the conversation from a policy perspective when we were coming up with having some, and we didn't want to make a new criminal charge either. So it's a civil penalty. Like, we were really trying to balance a whole bunch of things when we came up with that. And that's 3308C 11 is where we added that in, and you'll see that in the information I forwarded.
Thank you, Ms. Ward. What I really wanted to pull out is that there was a check and balance there.
Yes, absolutely. The conversation was, yep. And the work group was, again, public safety and prosecutors and defense attorneys. We had sort of a balance of folks involved in that conversation at the time.
And again, for the committee, what's really important to understand is what's current law within the juvenile area is that there is a penalty. There is a check and balance about the knowing, and you have to reach that standard about the knowing dissemination. And so I just want to make sure that that's clear to everybody, because it could be something that we eventually, that we should be talking about, and to not have it misinterpreted, as Mr. Freeman pointed out. There's quite a bit of room for that. And Jordan, did you have your hand raised?
Yes, I did. Thank you, Representative Talbot-Ross. I just want to point out one matter on page 5 of the chart for the committee's possible consideration. under the, what I'm going to call ineligible convictions. 17A, section 5541, capital A, endangering the welfare of a child makes it a Class D crime to knowingly permit a child to enter into or remain in a house of prostitution. And that is not listed in your exempted offenses. And I just wanted to bring that to your attention as I look at the list of noted crimes. 10 appear to be sexual exploitation of minors and others, but this one is not listed. So I wanted to bring it to the committee's attention for their consideration to do what they wish to do or not do with it.
Thank you for pointing that out. We'll go to Laura Ustek for a comment or a question.
Thank you, Representative. I have a couple of questions or observations that are pretty technical, and if I'm getting too much in the weeds, just let me know and I can follow up with Peggy about some of these later. But when you're getting into drafting, I think one of the questions you need to ask yourselves, just very simply, to whom do we wish the non-dissemination provision to apply? Should it apply only to the criminal justice agencies from where the information is originating, or should it also apply to someone to whom that information has been disseminated? And if it's the second one, does it apply to someone who has come into possession of it inappropriately, or does it apply to someone who is in possession of it legitimately and then secondarily disseminates it? And then say that explicitly in the statute. I don't know. I think there's a simpler way that it can be stated in the statute so that that's clear going forward. But the other thing I think is really important to know here is that what this LD does is it sets up a separate way to treat this type of confidential information than already exists in the Criminal History Record Information Act. So you have confidential criminal history record information, and then you have this other criminal history record information that is also confidential, but has different dissemination rules. And because of that there are potential conflicts. So for example, DHHS Child Protective has access to certain confidential criminal history record information. Well, what happens when that doesn't sync exactly with what's been made confidential under this LD? And do you want, why have you created two separate regimes for the treatment of confidential criminal history? And do you need to include a provision that says, well, which one applies when there is a conflict? So what's DHHS to do when they have access under the Criminal History Record Information Act, but they don't have access under this provision? You don't want that to have to come down to litigation. Just a couple other technical points. As Peggy was going through, I saw that there's a provision that the Secretary of State can have access for the purposes of federal motor vehicle laws. Well, do they need access to any of this information for the purposes of state motor vehicle laws? And maybe these are things that were addressed in the discussions last time. I wasn't clear on what the rationale was for including certain crimes on which the sentence was commuted. I just did not, and that's probably my shortcoming. I just didn't understand the policy distinction there. And then I also noticed that there was a difference in the counting of time. With respect to eligibility, the time is counted from the time the person has completed all aspects of their sentence. But in other cases, certain crimes are included or excluded based on the time that's passed since the date of conviction. And do you want to treat those inconsistently, or do you want to pick a consistent date and make them both from the date of completion of sentence? mean, maybe you want to treat them differently. I don't know, but I did notice that dichotomy. So again, those are some things that are really in the weeds, but just maybe go in that third column for drafting notes for Peggy.
Thank you very, very much. Yes, thank you, Emma. I was going to ask if you wanted to provide some comment, and then we'll go to Representative Pickett. And yeah.
Oh, thank you. I think I forgot to introduce myself when I first spoke, but I'm a housing attorney with Pine Tree Legal Assistance. I didn't have any further comments, I guess, or final thoughts on what I think about the Section 2 offense piece. I guess it seems like there's some, hearing Jill, it seems like there's some reason to give further thought to applying that section to people who are outside of a criminal justice agency. Just maybe further thought needs to go into who those people are, or what the limitations are when we talk about knowingly violating this, because I can see how it could be impractical to expect every news outlet to know the status of, I don't know. Anyway, it just seems to warrant more thought. I had some other just like comments or thoughts about the text of the bill. One was I'm noticing that we're carving out exceptions from the class D and E crimes. I was wondering whether there was thought previously in carving out some exceptions for the ineligible classes. So for example, an aggravated OUI is a class C felony. And, you know, I wouldn't want my clients to not be able to get into certain housing or obtain a certain type of subsidy because they, you know, had a higher blood alcohol level on one day that they made a mistake. I'm not sure that makes a lot of logical sense to me, I guess, to provide that kind of sweeping exclusion for all of those classes. And maybe it's worth thinking along the lines of Jill Ward's presentation on providing more discretion for the sealing of records for higher level crimes. I'm aware that maybe as a new member of this committee, maybe this has all been kind of talked through before, and maybe there's a reason that was settled upon, but I was just curious maybe to have a little more conversation about that as this committee, about why we're sort of grouping together those higher level offenses and not maybe disaggregating them.
Thank you. Thank you, Ms. O'Connor. Representative Pickett, would you introduce yourself and then certainly make your comments?
Yes, I apologize for getting in late. I drove to Augusta and I was went to the appropriations room, to my dismay, to find out that that was not on you. It was not going to be held in person today. So, but that's, I think, was probably my fault. I probably didn't get the memo or whatever, but anyways, I got back in time to join in for most of it. And my name is Dick Pickett. I am a representative for House District 116, the towns of Mexico, Dixfield, Canton, Hartford, and Peru. And the only thing I had, Representative Ross, is I think the questions or the concerns, whichever way you want to put it, that Laura brought up just a few minutes ago, I think it'd be nice to have those. If she could submit them to us so we could have them to look over as individuals, as well as when we have that conversation when it comes time to draft the bill. Thank you.
It's an excellent suggestion. Yep. Excellent. Will that work, Laura? Thank you. Yeah, excellent
Yes,
suggestion.
I can do that.
Thank you. And my apologies, Representative Pickett. I know time is precious, and I just apologize on behalf of the co-chairs for that misunderstanding.
Thank you. No
where the
problem.
meeting was. I think Courtney Allen, Ms. Allen has,
Thank you, Representative Talbot Ross. Peggy, you may have said this question, and I'm sorry if you already answered it. Does the LD that we're looking at apply to only under 21, like the previous sunset law, or is it everybody?
Oh, good question. It applies to everybody. That limitation was not included in LD 1459, so no age applies, and it applies to everybody that way.
Okay, that is what I was hoping for. Thank you.
the one piece I will add about the 1459 that we may want to consider is, again, and thank you, Laura, for bringing up timelines, but just this almost false calculation of time in setting 4 years. I don't know if folks who were part of the previous committee want to comment on it, but there was no evidence for that time frame. I just want to put that out there because we may want to think about it in light of the discussion we were just having about automatic or petition. The burden, as we see, is still on the individual. And if in the case of the sunsetted bill, if people do not know or they're not told by counsel, you get what you get. And so there is it could be argued that the burden is out of balance. Any other comments before? I'm not seeing anyone. Thank you again, Ms. Reint, for that presentation. And it looks like really pleased for this next section of our agenda. It is talking with committee member Peter Lehmann with the Maine Prisoner Advocacy Coalition and American Civil Liberties Union Council, Michael Cabede. We'll go in order of those two, and go ahead and feel free to introduce yourself before you speak. And I'm trying to find Mr. Lehmann.
I'm here.
Great. Okay. Thank you. Please begin.
Good afternoon, everyone. My name is Peter Lehmann. I'm the legislative coordinator for the Maine Prisoner Advocacy Coalition. The first time I came to Thomaston, where I live now, I was in shackles, en route to the old prison. I'd made serious mistakes, destroyed my life, those around me, and was paying my debt to society. The way our legal system works, a court delivers a sentence. In my case, that was 6 years in prison and 4 years probation. But that's not really the way it works. That's not the way it actually works. The reality is that I received a life sentence. The debt is never marked paid, and criminal sentences go on forever because of public criminal records. In my case, hitting a stone wall in employment and housing because of my criminal record. In my work with Prisoner Advocacy Coalition and the Reentry Network, I have worked with literally hundreds of returning citizens, and I've seen this struggle over and over and over again. In employment, in housing, even in access to recovery centers and other services. Did you know that a felony record disqualifies you from Match.com? In our view, public criminal records represent an unlawful extra-legal sentence or punishment for crimes for no good reason. The burden falls most heavily on the poor and racial and ethnic minorities who are overrepresented in Maine's prisons. The northern, poorest, and most rural counties in our state are also overrepresented in Maine's prisons, partly from the same dynamic. And this goes on and on and on forever. It's compounded by informal arrangements, such as organizations asking their local police department to do background checks, which come up with more than public confidential information. It's a life sentence, and that's not fair. Most felons do not repeat. Even among those with prison sentences, most do not reoffend. According to the Maine Department of Corrections, more than 70% of citizens returning from incarceration do not reoffend in the first 3 years after prison, the time of highest risk. So making records public is not fair to the 70%. And you know, making them public didn't stop the others from reoffending. It's simply not reasonable. There's also very good evidence that recidivism is partly a self-fulfilling prophecy. We predict that felons will reoffend, and so we use public criminal records to make employment and housing more difficult. And that further increases the risk of their reoffending. You know, we actually know that making criminal records confidentially actually lowers recidivism rates. Those with criminal records who are hired generally make better employees. The Center for American Progress, hardly known for its liberalism, estimates that excluding these people from the workforce costs the economy billions of dollars. Including them is not only the right thing to do, but it benefits everyone. And our conversations about this reflect the mythologies we carry about offending and reoffending, and that compounds the problem. For example, the severity of previous crime is not a good predictor of the likelihood of recidivism or the nature of the new crime. Violent criminals are not more likely to reoffend. Sexual offense criminals are comparatively unlikely to reoffend. We have data about that, and the Maine Department of Correction reports are consistent with that. For all of these reasons, we recommend, Maine Prisoner Advocacy Coalition recommends making criminal records confidential in Maine under Title 17, Chapter 7, except for mine. I don't want to be self-serving here. So you can keep mine public, but we also recommend strengthening the definition and penalties for breaching criminal records confidentiality in Title 17 and Chapter 7. And I'd really love to have you ask me questions. I tried to keep that short. Thank you.
You did a fantastic job, Mr. Lehmann. I want to remind committee members, so this on our agenda, this is number 3, requested information. The reason why it says that on the agenda is in LD 563 that created this committee under section 5 under duties. Number 5 says invite comments and suggestions from interested parties, including but not limited to victim advocates and prison and correctional reform organizations. So just call your attention to that as part of our duties for this committee, is to hear from Peter Lehmann and the organization that he represents. Any questions or comments?
I want to add that I also just emailed all of you a copy of my presentation with the appropriate, I'm an academic after all, with the appropriate footnotes and references, so that everything I said can be backed up by real data, not just hearsay.
Thank you. Yeah, thank you very, very much. And I hope that if there are no comments or questions right now, that we certainly utilize your expertise and lived experience as we continue to debate this in some of the, in the next meeting. Turning to—
It's a privilege to be here. Thank you.
Yeah, absolutely. Thank you. So Mr. Cabete, would you like to introduce yourself? And
Sure. I think Representative Pickett might have a question.
Great. Representative.
Before I start.
Yes, thank you, Representative Ross. Peter, good to have you with us this afternoon. I just wanted to make sure I understood your recommendation. Your recommendation was that all criminal records should all be made confidential. Is that correct?
Yes.
Okay, thank you.
You know,
Thank
one
you.
of the things that's fascinating about some of the proposals and the law that you've just been describing is that many of the carve-outs are, for all practical purposes, pulled out of somebody's hat. The number of years, for instance, is arbitrary. There is some research, if you'd like to use that, there is some research talking about what's the span of higher risk, et cetera. But that's not reflected in our proposals. And the carve-outs turn out to be, as I suggested, contrary to what we take as common sense. The mythologies simply are not correct most of the time.
Thank you. Mr. Bates, you had a comment or a question?
Yeah, I just have a quick question for Mr. Lehmann. Thank you again, everyone, for allowing me to be here. I really appreciate this opportunity. My question to Peter is that, do you know the data or have the statistics on those people who are serving 20 years or more reoffending upon release?
I do, and but mostly I have the Department of Corrections' own data, and among other things, it talks about age, and age is an awfully good age at release is an awfully good, and age, and obviously recidivism declines with age, and people with longer sentences, recidivism declines, but with age, even people with shorter sentences, recidivism declines.
So do you have any data comparing the shorter sentence to those with long-term sentence reoffending? For example, someone who's serving a 2 or 3 year sentence, what's the likelihood of him reoffending opposed to someone serving a 15-year or more sentence reoffending? Is there any comparison to that?
There is data available. Off the top of my head, I don't have it. I mean, I can't give you the reference, but there are references to that in the material that I just sent you.
Okay, thank you.
Yeah.
And perhaps it's possible to get that information from the Department of Corrections and others. Maybe we can try to provide that for you, Mr. Bates. Michael, please.
Thank you, Representative Talbot Ross. Thank you, the other representatives here and everyone else. Would people like a bathroom break or anything before I give brief remarks? I don't have a long speech or anything. Well, I won't be offended if you all turn your cameras off. So my name is Michael Cabeda, I'm Policy Counsel for the ACLU of Maine. And there's nothing that I can say that would add to what Peter Lehmann just said and what Representative Harnett earlier said about why criminal records should be sealed unless the state specifically designates certain criminal records to be made public. I think they covered that very, very well. What I would like to do is briefly describe two things. The first is why we think expungement is the gold standard and why a constitutional amendment to allow for expungement in Maine is necessary. And the second is the life and work of D. Clark, who was a member of the previous iteration of the Criminal Records Review Committee. So no court in Maine has held that the governor has the exclusive power to expunge records. But I believe it was the Attorney General who expressed that opinion to the Judiciary Committee in the last few years when an expungement bill came before the Judiciary Committee. So the Constitution of the state of Maine in Article 5, Section 11, Article 5 is the part of the Constitution that describes the governor's powers, states as follows. The governor shall have power to remit after conviction all forfeitures and penalties and to grant reprieves, commutations, and pardons. Now, as I understand it, Attorney General read that provision as granting the power to pardon people from crimes exclusively to the governor, and concluded that a court, if we passed an expungement law through the legislature, a court would hold that expungement law unconstitutional because the power to expunge, which is synonymous with the power to pardon, that's the Attorney General's reading, the power to expunge is exclusively granted to the governor. And so that's the argument for why expungement is supposedly unconstitutional in the state of Maine, unless the governor pardons you. Expungement is the gold standard, we believe, because a lot of the traces of someone's criminal record vanish once the person's criminal records are expunged. If coupled with a robust law that prohibits dissemination of criminal records, we believe that the only true way to give someone a second chance is through expungement. If we were to enact an expungement constitutional amendment, we would be joining a list of growing states, the most recent of which is Michigan. Michigan just passed a law that takes effect at the end of next year, 2022. Michigan is creating a system to automatically expunge eligible felonies and misdemeanors after certain periods of time. So Michigan, just like we're doing now, had a group of stakeholders agree to the list of crimes that would be expunged and automatically, and the list of crimes that wouldn't be expunged automatically. And my suggestion is that we start that process as quickly as possible. We've learned enough. We've gotten excellent information, and we've become very enlightened about the extremely complicated legal and bureaucratic landscape of criminal records in Maine. Now I think we have to start the work of agreeing, reaching consensus around which records should be sealed, which records shouldn't be sealed, and then broaching the issue of whether we are collectively ready to support a constitutional amendment to allow the legislature to do what Attorney General lawyers believe is only the governor's power. So that's my piece on expungement. Dee Clark, some of you will know her, just passed away in the last couple of months. And she was an extraordinary person. She was a victim and a survivor of sex trafficking, of sex slavery. And she was a leader of an organization called Survivors Speak USA. And she dedicated her life to ensuring that women who go through what she went through are able to live healthy, thriving, dignified lives. She died in her mid-60s. She died fairly young by my assessment. And one of the things she dedicated her life to was establishing what she referred to it as vacatur. That's just another term for expungement. Establishing an expungement system in Maine for crimes that women who are trafficked are forced to commit by their pimps. And partly because our Constitution is the way it is, partly because the Attorney General interprets it the way it is, partly because there wasn't much of political will behind Dee Clark's vision, that effort never really made it into legislation or into Maine law. But I do think that those of us who felt inspired by her life owe it to her legacy to make sure that this gets somewhere. And so that's my appeal to all of you who knew Dee Clark, and those of you who don't. There have been obituaries written about her, and I strongly recommend that you read them. She led a very, very extraordinary life and transformed the lives of lots and lots of people. And so that's the close of my presentation. And I see that the next thing on the agenda is a discussion about what we are prepared to enact. And so I'm very much looking forward to that, excited for that. I see two hands up. Happy to try and answer whatever questions they have.
Thank you very much for your presentation. I will add that in meeting number 4 for December 6th. I'm hoping that we can hear from some other folks as well. But Mr. Morgan, I think you have your hand up, and then President Bates, you have your hand up. We'll go in that order. Thanks.
Thank you, Representative Ross. Michael, that was a good presentation. I'm glad you brought up the kind of issue of expungement versus sealing, because that's something that I know MACTL and our clients are worried about as well. And we view expungement as the gold sort of standard, so to speak, too. And maybe you can now, or maybe once we start discussing things, you can expand on that more. But one of the key things I understand in terms of differences would be that if this group is going to identify people who are worthy of essentially not having to carry a criminal conviction going forward, those people would be empowered to say that it doesn't exist anymore. That's kind of like one of the key parts of expungement, correct? We're not putting people in a bind with a sealed conviction and possibly requiring them to lie or minimize. The definition of expungement would be essentially that the conviction did not exist. Am I correct in that assumption?
Yep. Yeah, it's a true clean slate.
That's all, thanks.
Thank you. I see Foster Bates, Samantha Hogan, and Laura Eustace.
I just have a quick question, because I'm not sure if I'm understanding this correctly, because my question is, what does the expungement or sealed record has to do with the governor's separation of power? I think I'm a bit confused there.
Yeah, happy to elaborate. So the separation of powers doctrine is the notion that powers explicitly and exclusively granted to one branch are not available to the other branches. The Attorney General reads the power to pardon, which in our Constitution is granted to the governor, as the same thing as expungement. In other words, to pardon is to expunge records. And since that power has been granted to the governor in the form of the pardon power, the legislature cannot enact expungement laws, because enacting expungement laws would violate the separation of powers principle. Does that clarify it, or should I go into more detail?
I think that might clarify. So basically what they're saying is the expungement and the pardons are relatively the same, or acting as the same.
Well,
that's expunge versus pardon?
Not necessarily. There are two different words. I don't think they are, actually. I think that the word pardon has a different history and resonance. If I were a Supreme Court judge in this law court in Maine, I would actually look more thoroughly at the history of the way those two words have been used in law and in society, and find out, are they actually synonymous or are they not synonymous? I don't think they're synonymous. I think the word expungement is the word expungement and the word pardon is the word pardon, but you could also argue that they're synonymous words, that they're the same, they mean the same thing. And so that has not been tested in court. This issue hasn't actually come up in a case in Maine, as far as I know. Correct me if I'm wrong, if other people know more about this, but yeah, so hey, we could pass an expungement law and see what happens.
My last comment is because I view them as being separate. So that's where my confusions came, because I thought pardon was you're pardon the person from the wrongdoing. And expungement is you're expunging a record, a criminal record or criminal history, only where the those who are in law enforcement or the criminal justice area could have access to those records, opposed to the public sphere. That was my thought process.
I agree with you. I think that's a reasonable interpretation of the two words. I think Laura Eustace had a question, Samantha Hogan, Barbara Taylor, or a comment.
Hi, Laura Eustace from the Attorney General's office, and I apologize for not introducing myself in more detail earlier. Just speaking on behalf of the Attorney General's office, I appreciate what you've brought up about the equivalency between expungement and pardon, and I'd like to add some nuance to what you have identified the Attorney General as saying. The Attorney General cannot predict for you exactly what a court will hold. And if I or anybody else gave that impression on behalf of the Attorney General's office, please don't believe that the Attorney General's office is telling you what a court will ultimately hold. I don't think that we can say that expungement is the equivalent of a pardon because we don't know exactly what expungement is. And we can't just look at the words. We have to look at the practical effect of whatever this thing is that the legislature may ultimately do. If whatever the legislature ultimately does, and it doesn't matter whether they call it expungement or clearing or peanut butter, if what the legislature does is the equivalent of clemency, that's going to create a separation of powers problem. What I can't answer for you is whether in fact it is the equivalent of clemency, because we don't know what all the practical implications are yet of what this committee is going to recommend or what the legislature is ultimately going to enact. So again, I think whatever is proposed, whether or not that's the equivalent of a pardon, that's going to be an open question. I think lawyers can raise flags for you as to whether or not it gets close to the line, but we can't ultimately answer that question. I think only the folks with the robes on can do that. Does that help?
I think that's very, very helpful and clarifying. I appreciate that very much. I'm sure others do as well. And your reasoning is why we think a constitutional amendment would be the best path forward, rather than just passing an expungement law.
I think I was next in line. I'm Samantha Hogan. I represent the Maine Press Association. I am also a reporter for the Maine Monitor. Thank you for including us in this round of the Criminal Records Review Committee. I was glad that Michael brought up the Michigan law, which I think was provided to us in our binders, actually. Michael, do you know, was that the set-aside law? That it would be behind tab 7, right behind that blue sheet of paper? If I'm looking at the same thing. The only reason I bring it up is because I did highlight something that I think that we could consider in light of Mr. Freeman's presentation. They also have a prohibition on disseminating information after it's been sealed. They got taken an extra step further, making it a misdemeanor, punishable by jail time. But then directly below that, so at the very, very end of the bill, I guess subsection 6, it says that an entity is not liable for damages or subject to criminal penalties under this section for reporting a public record of conviction that has been set aside by a court order or operation of law if that record was available as a public record on the date of that report. And I did highlight, I did read the majority of the binder. So, and that just did stick out to me as a possible starting point for a solution for what we discussed earlier. And then while Mrs. Ward was talking, I also made a note that I wonder if there is an ability for us to add in somewhere a place for the public to petition to look at sealed records for a legitimate public interest, or whether or not there needed to be a provision that said that records already in the public domain, that you couldn't apply the offense section or the just looking at those as potential solutions. So that's what came to mind. And Michael, was that the law that you were referring to?
I think, yeah, that was part of it. They passed a whole expungement and sealing package, and I think what you read from was a part of it. And what you identified, both in the bill and your suggestion, I think are really great starting points for our next agenda item discussion. So
yeah, because I know that I personally, I have court records all over my office that I've pulled at different points in time, and I don't know if you've ever been in a newsroom, but journalists tend to hoard a lot of paperwork. And some of the real old grizzlied guys will be like, oh, 1998, and pull out the court record from there. And it's not that they have it digitized anywhere, but they remember writing that article, they remember covering that trial or seeing that guy at arraignment. And so, I mean, sometimes these records do exist inside newsrooms, sometimes they don't. And the one thing I did want to point out, an example that came to my mind, is that we quite often, as reporters, get tips from the public who remember a misdemeanor that potentially could be sealed under what's been currently proposed, a Class D, a Class E. And they're going to bring it to a reporter and they're going to say, hey, this guy did this at this time, and now he's running for the local school board. Well, my thing that I immediately say to people is, I can't run rumors. I've got to fact check this on my own. Let me look into this and I'll get back to you and make a determination whether or not it is newsworthy and correct. Is it truthful? So if some of these records go under seal, that's why I want us to be able to potentially petition to look at whether that record has a legitimate public interest, whether that person is seeking, a place where they're working with children, some other place of public trust. I mean, there was talk about potentially adding OUIs to this. I mean, the question that always comes to mind is, do we want bus drivers that have OUI convictions? So there's just several things to weigh on why people such as journalists would, or the public in general, would want to be able to look at some of these records, even if they're later sealed. Thanks.
That is really great. Those are phenomenal ideas, and thanks for suggesting them. I think we have Barbara Taylor, then DA Sarbeck.
Thank you. I just wanted to add a nuance as well. I just wanted to remind everybody, forgive me if I sound like a broken record, that for Maine residents who are not US citizens, an expungement will do nothing to erase a conviction for immigration purposes. Often a governor's pardon or even a presidential pardon will not do it either. The conviction remains a conviction for immigration purposes, regardless of all those rehabilitative actions. As a result, it will be very important that Maine residents who are not US citizens be able to access those records. They will be required over and over again to produce them for immigration. The burden will be on them to produce them. So in addition to supporting a lot of the great ideas that people have today, I am also going to hope that we will talk about how to ensure that the subject of records has access to records.
That's a great reminder. Thank you, Barbara Taylor. DA Sarbeck.
Thanks, Michael. Michael, what would be required to get a constitutional amendment?
2/3 of the legislature.
Okay. Is a referendum required for the state?
Yes. Yep.
All right. Thank you. I just didn't, I know it federally, procedurally to get a constitutional amendment, but I wasn't sure what was required for Maine. So, all right. Thanks.
Yep.
And just for a little clarity for the public, that means 2/3 vote by both chambers of the legislature. The governor has to sign it into law, and then it goes to the voters. So it's quite a process, purposefully so. Any other comments or questions? And so I hope if any of the members are missing any information, I thank you, Samantha, for calling our attention to the Michigan law in our binders. But if anyone's missing any information, can't access it, please let Jane or Peggy know so that you have it. And I hope that members before the next meeting will take a look at specifically what's happening in Michigan. And I thank you again, Mr. Cavede and Mr. Lehmann, for your presentations. We'll get others at our next meeting. It is now 3:45. We will adjourn promptly at 4 o'clock, unless we can do so earlier. On the agenda, we still have just the folks. we should talk a little bit about how we're going to bring forward, recommendations. We have, 2 more meetings, and it's really, really important, I think, to many of us who had worked on 1459 to move something forward. We also have the suggestions that Mr. Lehmann has made and Mr. Corbett has made. Can folks just comment on anything that they're feeling ready to? We have a lot more discussion, but is there anyone that's got any comments about the willingness to entertain 1459, the idea of a constitutional amendment? Because our next 2 meetings hopefully will be a hybrid, and maybe we can get more conversation going if we're in person, but we are trying to move towards some recommendation coming out of the committee soon. Jonathan, DA Sarbeck.
Thank you, Representative Talbot Ross. I mean, personally, I think if we're going to do this, we need to do this right. And to me, what Michael was just talking about with regards to the constitutional amendment, it's one of those, do we spend the time on doing a statute that ends up being deemed unconstitutional for some reason? And that is, or as Courtney pointed out earlier today, do we end up using it, putting together a statute that is very rarely used? So I'm kind of leaning in the direction of why not try to address this in a manner that's going to be best with regards to something that's going to be utilized and also stand up to any constitutional challenges that might come, with the same idea that we address the issue that was mentioned at the beginning with regards to looking at this globally to make sure that it's those Supreme Court cases that I think the concern was whether or not you're going to challenge or somebody's going to be quote unquote in trouble if they disseminate information that has been sealed or has been expunged at this point. So I think we would have to make sure that we're thinking along those lines too. But to me, I think if you're going to do something, especially with the group who's putting so much information or so much work and effort into it, that we do something that's going to be lasting. Because I know the last one did it, and as was mentioned earlier, they probably didn't view it as a pilot project, and it just sunsetted and it's gone now. And it gave us some good framework, but I think we could do a lot more.
Thank you very, very much. Thank you. So seeing no other comments.
Representative Talbot Ross, can I jump in?
Please.
I'm seeing it as a both and. I think we should put forth 2 recommendations. One for an amendment of the Constitution as outlined by Michael, and then also putting forth the LD with the recommendation of it being an automatic process. So ensuring that it can stand up to the constitutional process, and that we get both things from this work.
Thank you. Thank you. I'm hoping that when we do get together on the 6th, some of us in Augusta, some of us by Zoom, that you'll bring forth, and really, I guess that's the call right now, is that we have been inundated with a lot of information, but it's now time to move towards some decision making. And so I just encourage those of you who haven't commented or may need some more information to come prepared for us to try to narrow this into some decisions. DA Sarbeck, did you want to make any more comments? No? Okay.
I'm sorry, I didn't lower my hand. My bad.
No worries. I just wanted to check. So we will move into our last 10 minutes planning for meeting number 4. Peggy, Jane, should I turn this over to you and you can talk about what we're hoping to do?
Well, I actually, I don't want to take us backwards, but I was trying to think earlier of what the constitutional amendment would be. And I'm wondering if somebody who's worked on that in the past or is really familiar with that could describe it. It would be a constitutional amendment to do what? That's an open question.
I guess it would be expand the expungement power or allow for it. I don't know exactly how it would be written.
I suppose we could go many ways about it. Representative Harnett, sorry, I just jumped in.
Well, I thought it, no, why don't you continue? I think there are many ways to go about it. Why don't you start there? Sorry.
Well, I stopped thinking when I saw you were about to talk.
I guess I stopped thinking when I saw you talking. I thought what you were suggesting was to amend the Constitution to give the authority to grant reprieves, commutations, and pardons to the legislative branch rather than having it exclusively within the executive.
Yeah, but I suppose I don't want to do it in a way that deprives the governor from pardoning people as well.
Okay, so it might be vested in two.
Exactly.
Branches.
Yeah.
And Michael, that would, because you've made pardons and expungement as proxy, we would, you'd have to include it, you'd have to include them all because of the way in which interpretation for both and exist.
Yeah, and I suppose, Laura Eustack's point here is very well taken, that it's the consequence that matters, perhaps even more than the words. And so the power that's granted to the governor is the power to grant reprieves, commutations, and pardons. And that list of things creates the same outcome that expungement creates. And so I think that list of things would have to be allowed not just to the governor, but also to the legislature, or perhaps exclusively to the legislature. I don't know how people in this group feel about that.
Peter Lehmann and then Representative Harnett.
Yeah, I probably don't understand this, and you can help me with this, but as I understand it, what the power of pardon means is actually defined in the statute that the legislature has adopted. In other words, the statute 16, Chapter 7, the confidential, the Criminal History Records Act is where it calls for expunging that stuff and calling it or calling it confidential in our records. So interestingly enough, it appears that the legislature has defined what pardon means. I don't know where I want to go with that, except that, that makes it even more complicated in my mind.
Representative Harnett.
My hand was actually down. I'm sorry.
Okay. So I don't know if Lauren knows this, or we need to ask Jane and Peggy to look at it, but a bit of clarification about that, obviously, is what has been defined.
Hi, this is Laura. Sorry, I'm having trouble activating my video, but no, the purpose of including pardon in the Criminal History Record Information Act is just to make clear that if a full and free pardon has been granted, that information related to that conviction, what was previously that conviction, is now treated as confidential. It doesn't, in fact, define a pardon. It just says how the information about the conviction affected by the pardon is treated.
Representative Ross, if I might jump in, I don't know if you can see my hand or not. I think where Michael started was that, and I think Laura agreed, was there really isn't a decision on this. So we're kind of assuming one way or another that we would need to amend the Constitution when maybe we wouldn't. And it's not unheard of for laws to be struck down as unconstitutional and the fix to be a legislative fix. So I think if we went forward with an expungement law and it was in fact challenged, then the result would be that the legislature would then know its powers are limited to sealing. I think boxing ourselves in here and talking about doing a constitutional amendment that would possibly take powers away from the executive branch, which I don't think is anyone's goal, is probably a messier way than that way forward, would be sort of my 2 cents.
Representative Pickett, please.
Yes, thank you, Representative Ross. My understanding of expungement, from what I know about expungement and expungement of records, is when a record is expunged, it disappears, it's gone. It no longer exists. Case in point, a personnel complaint, some kind of decision in personnel. And there's a provision within personnel laws to be able to expunge a record. That record is no longer part of the personnel file anymore. So I think, and why I say that is this, I think it goes back to what Laura said a while ago, and that is we need to really determine what expungement really is for the purposes of what we're trying to do here. And I think we've had a lot of good information today talking about that, and we certainly got a lot of information to be thinking about. But I do agree with you, with only 2 more meetings to go, we need to now begin to think of how we're going to pull these things together. And I think we're throwing out some ideas here of what might be a good idea, might not be, such as, should we try to take powers away from the executive branch, or shouldn't we, which we just heard, and these kind of things. But I think now we have that stuff that we can think about, and we can actually consider over the next couple of weeks, so that we can come back and have a good conversation regarding of what do we really want to do, what course do we want to take, and then put that course into play. Thank you.
I think we all appreciate that, Representative Pickett. Thank you for that. And perhaps between now and December 6th, we should probably get some information out, looking at Peggy and Jane, around the we have definitions, but where does some of these powers exist? And looking, as Michael has directed us, into thinking about the separations of power and who gets to do what, because it does appear, as Matthew Morgan has suggested, that maybe there's a different route that we want to go for the legislature that doesn't put the governor's authority in jeopardy, really. Or more applicable. So it is 4 o'clock. Any other comments? I want to thank you all for such a engaging meeting, and thank you for your patience in the last several meetings of just getting so much information. But it is now time to kind of pivot into our next 2 meetings, into making some decisions about where this committee is comfortable in going. And then, as you've seen on the list that Jane provided, we will try to get it past this next regular term for this committee to continue its work. And it would be helpful to know as we move along, if you're interested in serving on this committee, still remains, because there's quite a bit of work to still do. Any last comments from anyone at all? Jane, Peggy, committee members? Yeah, please.
Peggy and I'll get you the Michigan law or laws that form that packet. So you have them. You have a lot of information in your, is there an echo? Yeah. Oh, there is on my side. Okay, I'll just ignore it. There's a lot of information in your resource book. I would just caution you when you're looking at if you look at some of those charts or descriptions of state laws, to be careful to look at the definition, because some of the laws that talk about expungement or erasure or vacature then have a provision that that if you're rearrested or reconvicted, the record comes back. Well, it can only come back if it didn't really go away. So be careful, the definitions really count. And we'll get you Michigan.
Yeah, and we have the materials that were presented today. I think Jill Ward sent us her materials, and then we have already what Peggy had put out. So I think we're in good shape. If anything comes up between now and December 6th, please do not hesitate to reach out to Senator Bailey or myself or Jane or Peggy. We really want to make December 6th a very, very productive meeting. So please come prepared for that. And I just want to end, since Michael was kind enough to remind us of our good colleague, Dee Clark, who did serve on this committee and the previous committee. We should end in her honor. And thank you for bringing that up, Michael. So,
Rachel,
yeah.
before you go, I want to wish everyone a happy Thanksgiving and enjoy your turkey and all your festivities, and be safe.
Absolutely.
Thanks,
To all
Bosley.
the committee members, happy holidays, and we'll see you on December 6th. Thank you very much.
Thanks.
Thank you, Rachel.